Yeah. Broadcast is live.
There you go.
We're on.
Good afternoon, everybody. It's Jeff Jenkins and Eric Klayman here again for our pretty much weekly Facebook Live presentation. Today we're going to talk about bankruptcy and the interplay between bankruptcy and family law and criminal law. And both of those topics can get kind of convoluted, complex. What else starts with C?
Murky. That doesn't begin with a C.
Yeah, no.
Convoluted, complex. I'll work on that.
Anyway, we'll keep it simple rather than complicated. So,
Jeff, how many times have you gotten a call from a lawyer, and we're not even involved in the case, and the lawyer says, "Hey, you guys know about bankruptcy. I'm doing a divorce case, and the judge won't let me go forward because someone filed bankruptcy." And what's the answer to that?
well, I mean, you get those questions once in a while. The answer is that the state divorce court and the bankruptcy court have, in a manner of speaking, concurrent jurisdiction over the whoever filed the bankruptcy and their property. And we're gonna talk about that some. But when you file, if a bankruptcy is going on and a divorce is filed, or vice versa, there are exceptions to the protection provisions of the bankruptcy laws. They say that despite the divorce going on, there are certain things that the divorce court can do.
Despite the bankruptcy going on.
Despite the bankruptcy proceeding.
Right.
Exactly. And one of those would be to establish visitation if there's children, or paternity if there's children and a dispute about that, custody, and of course, dissolve the marriage itself.
So Jeff, you're saying that if somebody gets sued for paternity, filing bankruptcy doesn't protect them?
That's correct.
Okay.
Yep, that's right. Excuse me.
But there is some protection provisions that could be in play, but you're right, Jeff, and that's the answer I always give is, first of all, divorce. If both parties come to the marriage with very little and leave the marriage with very little and very few bills, and they just want a divorce, a bankruptcy really shouldn't even play a part, although we receive the calls all the time, several calls a year from divorce lawyers who the judge wants to stop it, the other side wants to stop it. A divorce, and as you said, a paternity, custody, visitation, all those kind of non-money, non-property issues, the bankruptcy judge doesn't get in the way of those.
No.
And Congress was clear when it wrote the bankruptcy court.
Yep, absolutely. These things are very specific in the bankruptcy code. So the state court judge who's taking care of the divorce proceeding can certainly go forward with almost everything without talking to the bankruptcy court. The only real exception would be property settlement, because if you've got one person doing a bankruptcy, they're both in divorce court, the bankruptcy court would maintain jurisdiction, if you will, over their property. And not only the bankruptcy court, but if the trustee, which whether it's a Chapter 13 or a Chapter 7, might be very interested in what's going on with the property.
Right. You could imagine a very convoluted situation in which there's shenanigans going on. And the husband has a lot of bills and decides to file bankruptcy and decides to file divorce. And the divorce decree says the husband keeps all the bills and the wife gets all the assets and we move on with our lives. Those are the type of things that it's the shenanigans that the bankruptcy court, the bankruptcy trustees want to take a good look at before the property settlement can go forward.
Yeah, but I think Eric, they want to certainly want to make sure that the property settlement's fair and equitable as far as the creditors are concerned. And you were positing a situation where the creditors just kind of got cut out of the thing, and the wife walks away with everything, or the husband does. However you're doing it.
Right, and that's what they're there to protect. So basically, we see it a lot because money problems and family problems are, not surprisingly, there's a relationship. Look, if you have a lot of money, perhaps it's easier to be happy all the time. Or if you can't pay your bills, perhaps it's a little harder to be happy all the time. When you're not a happy spouse, happy life. And sometimes that leads to, so we see this a lot. Talk to us. Other lawyers call us. People who aren't our clients call us because this question comes up. And in New Jersey, we're known as bankruptcy lawyers who can give you the answer to this.
Right, exactly.
In fact, if you have a question about this or any other type of interplay between divorce and bankruptcy, or just you're having problems where you have a colleague, friend, or coworker who are having a tough time paying their bills right now, the phone call's right on the screen. Give us a call. When you call, ask for Jeff's book. It's our pleasure to give you Jeff's book. And there it is. It's Make Bankruptcy Work for You. And it does have a little bit in here about the divorce laws and how they interplay with bankruptcy, but it really gives you some good fundamental background on bankruptcy law and how we can help you. The other thing I can recommend is our website is new and improved, jenkinsclayman.com. And if you want, you can go back. There's a video section. We have several of these videos. You can just kind of go through them. They're listed by topic. Mm-hmm. And if there's a particular issue bothering you, a friend, a colleague, a coworker, you're behind with your rent, you're behind with income taxes, behind with credit cards. These are the most common when people call us. Just look at the video. Give us a call, ask for the book. And knowledge is power. Jeff, I've got a question for you.
Yeah.
And this comes up, and sometimes it's uncomfortable because they're friends of ours and colleagues. But in a divorce or in a family law dispute, if the person incurs attorney's fees and they're unpaid, can they be discharged, legally forgiven in a bankruptcy proceeding?
Yeah, the person who's filing the bankruptcy is the one who incurred the attorney's fees as part of the divorce proceedings. That's just another unsecured debt as far as the bankruptcy court is concerned. So just like a credit card, medical bill, it can be erased. And that's tough. You know, if a divorce lawyer calls us up and says, I've got a referral for you.
You may not get that second referral.
What do you want to hear first? The good news or the bad news? No.
Yeah.
Now, on the other hand, if as part of the divorce proceeding, the judge, the state court judge, tells one of the parties that they have to pay the other party's attorney's fees, those are generally seen as of the nature of maintenance, alimony, or support. And so just like those things you can't get rid of in a bankruptcy, no matter what kind of bankruptcy you do, you could get rid of those attorney's fees. And that's important to keep in mind. Another thing, Eric, that we see sometimes or get questions about, we have clients come in and they think that they got a bad deal in the divorce and the bankruptcy can do something about it. And the bankruptcy court is not an appellate court. It's not going to reverse the decision of a state court judge in a divorce matter.
Or quite frankly, in any dispute where there's a final order. And we see that. We see sometimes people get sued, two neighbors sue each other, and it's fraud or some bad determination. And the defendant who lost in court comes to see us. Now, the debt itself can be treated in a bankruptcy court, by the bankruptcy court, by our bankruptcy laws. But if there was a determination in the state court, a final judgment, the amount of the judgment or the nature of the judgment will not be disturbed by a bankruptcy court. Although, interestingly, and I know we're going off topic, the state court does have a different definition of fraud at times than in the bankruptcy court. And we know that bankruptcy court fraud is not forgivable. Sometimes state court fraud does not fit the definition of fraud.
Yeah,
but I don't want to go too far.
Yeah, we don't want belabor it, but that's true. That fraud in state court is not necessarily fraud in the bankruptcy court. And debts incurred where there's fraud involved are going to be non-dischargeable, whether it's a Chapter 7 or a Chapter 13. That was one of the changes they made in 2005. They made, it used to be that fraud was dischargeable in Chapter 13. The last 16 years, it hasn't been. But the way the bankruptcy court looks at things and the definitions they have to follow of what fraudulent behavior is would be different from a state court proceeding. And so just because there's a judgment against somebody in state court that says there was fraud involved, that doesn't mean that the bankruptcy judge is going to agree with that part of it anyway. They're not going to overturn the judgment, but in the bankruptcy, they will not pay attention to the fraud and allow the debt to get discharged.
This is what Jeff and I do all the time. He comes to my office. This is my office. He asked me a question about family law, and all of a sudden I pushed us to talk about fraud. But they're related in a way, I guess. The point that Jeff was making at first is still the point, which is the bankruptcy court is not an appellate court.
Right.
There's just sometimes different definitions. That's why you need to call an experienced bankruptcy lawyer whenever you have financial issues. A colleague of yours, a coworker, a friend, a relative, call us and we can go over this. And what seems obvious sometimes is less than obvious. And Jeff, in addition to the many calls we get from people going through divorce or marriage dissolution issues, we also get a lot of people who have slight issues with the law, up to big issues with the law. And we get calls, and there's a lot of different types of debt that involve criminal law or municipal court, as we call it in New Jersey. Sometimes municipal court and criminal law. There's a lot to learn, a lot to know about how they're treated in a bankruptcy case.
Should we finish up with our family law stuff?
I thought we were finished. I think we're finished. It's 10 minutes. Go ahead. What else would you like to say?
All right. If you're in a bankruptcy and you owe maintenance, alimony, or support, that's something that's not dischargeable. We mentioned that before, but your tax refund can still be garnished despite the bankruptcy proceeding, and your wages can still be garnished to pay maintenance, alimony, or support despite the bankruptcy proceeding. So those are exceptions to the protections that the bankruptcy norm would offer someone.
Right, we can expound on that because when people see us and they have a wage garnishment in favor of someone who sued them, or even the IRS has a wage garnishment against them, which happens a lot.
Yeah.
We stop those wage garnishments right away. That's what a bankruptcy filing does.
That's not a problem.
However, what Jeff was saying, if it's child support and it's a wage garnishment, there's very little we can do.
Yeah. There's another thing that a lot of states have, certainly New Jersey does, and that is if you're not paying your child support, maintenance, alimony, or child support, licenses can be revoked. And not just your driver's license. Could have a license to be a plumber or a barber, whatever.
Even an attorney at law.
I guess.
Yeah.
So that's kind of also another exception to the protections the bankruptcy affords. It doesn't protect you from that. And this is another thing that I'd like to point out. This is important, and probably of all the things we're saying, it's something that should stick in your mind. And that is, if you do a Chapter 7, you can't get rid of any property settlement things. So property settlement as part of the divorce proceeding. Whatever it says, if you do a Chapter 7, you can't alter it. In a Chapter 13, however, you can. Property settlement debts are dischargeable, just like a medical bill, credit card, unless, like I was talking about before, the property distribution can somehow be seen as of the nature of maintenance, alimony, or support. And there's times when it can. But that's a very important distinction, and a lot of times it might dictate what kind of bankruptcy we do. Whether we're going to do a Chapter 7 or a Chapter 13. we have anything else about the family stuff?
I skipped. I'm in the penalty box for skipping to criminal law already. I think we gave people a good background. Again, you can give us a call and just ask for Jeff's book, get a little bit more information on this, and we're here to help. And just call us for questions. There's no obligation. So if you have a particular marriage dissolution support family law issue that deals and you're having problems paying your bills, give us a call. We'll be able to talk to you.
Yeah, absolutely. What else?
I wanted to talk about people who drive and they get stopped by the police.
Okay.
And then they owe a lot of money and they can't pay it.
Yes. Well, and we're going to talk about that. In Chapter 7, one of the things one of the paragraphs that talks about things that you can't get rid of are fines, penalties, or forfeitures. You can't get rid of those in Chapter 7. And in Chapter 13, you can get rid of them. But you can't get rid of a criminal fine or restitution based on a criminal proceeding. So it's fines that a municipal court would dole out are generally not seen as criminal fines, but there are other fines in larger courts that would be criminal fines.
That doesn't mean that we can take all the teeth away from a municipal court. So based on what Jeff said, if you do a Chapter 7 to get rid of your credit cards and medical bills, we include the municipal court on the list of creditors. So they're aware you're having financial problems. And what we recommend is you then call the municipal court and make payment arrangements, assuming that the fine is there and you've already pled guilty. Of course, if it's for failure to appear, call our office because it's complicated. Almost nothing that I'm going to be speaking about deals with failure to appear, okay? But assuming that there's a fine against you, municipal court driving fine, for instance, a Chapter 7 won't get rid of it, but we have found that if you otherwise wish to do a Chapter 7, we can help you get a payment arrangement with the municipal court. And because you don't owe anybody else any money, you're in better position to pay the municipal court and move on with your life. Now, Chapter 13, the payment type bankruptcy, we have a lot more flexibility. And in fact, in pretty much in all of New Jersey, or just about wherever we deal now, because we've been doing this so long, we've worked it out that the municipal courts accept the Chapter 13 as a bona fide payment plan and will set aside a driver's license suspension based on failure to pay a fine. We've had great success with that. But then you have to pay it back because we don't want the municipal courts to impose what they call alternative penalties.
Which they can do in New Jersey, and that's something that we don't want to happen, because an alternate penalty might be jail time. The judge might say, "Hey, Mr. Smith, I don't care about that fine anymore. You're going to jail for a certain number of days," and we can't stop that. It's a criminal proceeding, and that's kind of a tenet of bankruptcy law, Eric. If it's a criminal matter, a real criminal matter, the bankruptcy can't do anything with it generally. But civil matters, it can.
That's exactly right. Now, Jeff, the state found a good way to raise more money about 20 or 30 years ago, because it felt like, who would object to charging people who commit criminal traffic fines? Who would object to charging them even more money? Because a voter can't say, "Hey, I'm a bad driver, so I'm against this." So the politicians passed this law, the New Jersey surcharge law. And that basically says if you've gotten fined, you owe this. Not only do you owe the municipal court, so here in Audubon, you're stopped for speeding. We see this right in front of our office all the time on the White Horse Pike. And if it's a bad enough speeding fine, not only do you owe Audubon after you plead guilty or found guilty, you then owe the state of New Jersey Motor Vehicle Services, formerly Division of Motor Vehicles, what's called a surcharge. And is that a fine, penalty, or forfeiture?
Well, that's a good question. And the only judges that have tackled that question in New Jersey, and maybe, well, I don't think Pennsylvania has surcharges.
Not
So-
so it's written here.
So it's only been bankruptcy judges that have addressed this. It's never gone to a federal district court judge or Third Circuit Court of Appeals. And so there is no law of the district. So whatever a bankruptcy judge says is not binding on all the other bankruptcy judges, or binding in the district. And I've seen some long opinions about that, with the judges struggling with, are these surcharges a fine, penalty, or forfeiture? Because if they are, then we can get rid of them in a Chapter 13. But we couldn't get rid of them in a Chapter 7. And it seems that what I've found, that I've seen anyway, it's kind of like the last opinion by a bankruptcy judge is what the motor vehicle folks follow. So if the judge says you can get rid of them in Chapter 7, that's the way it is in New Jersey for a while, until a judge comes along and changes and says,
But as of May 2021, if you do not own real estate, we have been getting discharges in Chapter 7 for surcharges.
Yes.
Of course, if you're listening to this in June 2021, give us a call, and that was Jeff's point. And Chapter 13, we certainly are getting rid of surcharges. Again, if you own real estate, it's something we have to look at with a little bit more detail. But for those of you who are less familiar, and I've been joking about the surcharges a bit, if you're stopped for drunk driving and you lose your license for 6 months, it's tough to maintain employment. You pay a lawyer a lot of money, you pay a municipal court a lot of money. Sometimes you lose your job because you can't drive anymore. And then you owe surcharges of typically, I don't know, $1,000 to $2,000 a year for 3 years. That's $6,000. Sometimes it's more. So it's really a significant debt. I don't think anyone files bankruptcy just because they owe $3,000. But what happens is it's really, it's a straw that can break a delicate camel's back. And we do see people who owe surcharges, and it's not their only debt. There's a statistic, Jeff, I think over 90% of consumers who file bankruptcy owe medical bills.
Right.
And you hear that and you think, oh my goodness, the medical bills are crushing the economy. Well, it doesn't mean that everybody filed bankruptcy. 90% filed because of medical bills. Right, and similar to surcharges, most of our clients don't file just because of surcharges, but it's a bill that we can get rid of. And Jeff, New Jersey as a hammer to collect surcharges can suspend licenses for not paying surcharges as well.
That's exactly right. And many of our clients come in here, in fact, with their license suspended because they haven't paid surcharges. And every once in a while, we might get a client. I think we had one of our clients in, not last week, but the week before, maybe, who had a lot of surcharges and a lot of fines, had maybe more than $10,000 of each. So we do see that from time to time.
And we can help people. If you've been stopped for drunk driving and you have a 6-month suspension, but you didn't pay your surcharges and you've done the 6 months, you paid your municipal court fine, you've paid $150 to motor vehicles for restoration, but you can't get your license back just because of surcharges. We can get your license back in a week typically. I mean, that quickly.
They're very good. The motor vehicle people are very responsive to us when we call them up and tell them we've got somebody who filed a bankruptcy and a license is revoked. They'll reinstate it right away. And so that's good news.
Jeff, I was too enthusiastic today, I think.
Why?
I'm going over the time.
Oh, we're doing good. We're doing good. I guess I think it's about time to sign off. So it was good talking to you again. And next week we won't be doing this because I'll be someplace else. But the following week, on Thursday at 2:00, we'll have the same Facebook Live presentation with a different topic. So until then, everybody stay safe and God bless.